Good morning, Hong Kong, and welcome back to another episode of Hong Kong Insurance 101. Last week, we investigated how different insurance principles were applied to the handling of pre-existing medical conditions under health insurance policies. In that video, we noted that because of the complex nature of pre-existing medical conditions and the fact that these conditions are normally excluded from coverage, some applicants may attempt to hide the existence of a pre-existing medical condition when applying for medical insurance coverage. Today, we're going to be talking about utmost good faith and why not disclosing material facts on an insurance application is actually harmful to your interests. It should be understood that the principle of utmost good faith applies to all policy types and insurance product classes in Hong Kong. So, first things first. Under Hong Kong law, contracts are subject to the principle of good faith. This means that both parties are expected to be honest and supply information which is substantially true. This is ordinary good faith. While both parties must supply contractual information which is substantially true, it is neither party's responsibility to ensure that the other entity obtains all the relevant information that may affect the contract. However, insurance is far stricter than this. Remember that in order for policy coverage to be truly considered insurance, there must be equity on both sides of the contract. In Hong Kong, rather than ordinary good faith, insurance contracts are subject to the principle of utmost good faith. Under insurance law, each party involved in a contract of coverage has a legal duty to reveal all necessary information, also known as material facts. This has to happen whether or not the other party has asked for that information. In Hong Kong, the statutory definition of a material fact is each and every circumstance which would influence the judgment of a prudent insurer in fixing a premium or determining the acceptance of a risk. Now, both the insurer and the policyholder must disclose all material facts as the contract of insurance must be equitable. While the policyholder must disclose the information in relation to the risk they are covering, the insurer is also responsible for offering information in relation to the policy conditions, the renewal terms, the length of coverage, and any terms and conditions which could impact the overall coverage. Both the insurer and the policyholder can breach utmost good faith. However, it is normally the insurer which is the hurt party in a breach of utmost good faith. Should utmost good faith be breached, then there are a number of different remedies, including voiding. The insurer can void the entire contract of insurance from inception. Premiums paid in a fraudulent breach are kept by the insurer. Legal action. In addition to voiding the contract, it is possible for the aggrieved party to sue for damages in a court of law in the case of fraudulent or negligent misrepresentation. And finally, waive. The hurt party, which remember is normally the insurer, agrees to waive the breach and the contract becomes valid on a retrospective basis. Because pre-existing medical conditions are so complicated, and because many insurers will simply exclude pre-existing medical conditions from coverage under their plans, many applicants may actually attempt to hide or not disclose a pre-existing medical condition to the insurance company. However, a pre-existing medical condition is a material fact. And as we've seen here today, under Hong Kong law and the principle of utmost good faith, both parties, especially the applicant, have a duty to disclose these facts whether asked for or not. Attempting to conceal a pre-existing medical condition in order to have it covered by a health insurance policy would likely be considered fraudulent misrepresentation. You're probably going to forfeit any and all premiums paid and could see yourself become the subject of a legal action. Pre-existing medical conditions are normally defined as any condition for which the policyholder has received diagnosis, treatment, or medication, or any condition for which they have displayed symptoms or of which they were aware prior to the commencement of an insurance plan. Failing to provide the details about any medical conditions you may be suffering from, even if they have not been formally diagnosed, and if you have never received medical treatment, is actually a breach of utmost good faith under Hong Kong law. This is primarily due to the fact that you have not provided the insurance company with all of the information it requires to fully underwrite your policy, and consequently the coverage in question is not going to be equitable. That's us for this week. As always, we hope you have a happy and healthy weekend. Remember to like and subscribe to stay current with all our content as it comes out. And don't forget to ask CCW. We're simplifying your insurance.